at the time the cause of action arose. As at the time the cause of action in this case arose, it is the 1999 Constitution as amended that applies. Coming to the substantive case, the claimant in this case, in an attempt to prove her case, testified as CW1. After identifying her witness statement on oath, adopted it as her evidence, CW1 tendered documents in evidence in the course of the trial. They were admitted in evidence and marked as exhibit CW1A to CW1L. The claimant in her claim is seeking for declaration that her employment of 3rd day of February 2019 is still valid and subsisting, and the purported cancellation of her employment by the defendant is null and void and of no effect whatsoever. In law, for an employee to claim payment of salaries, he has to prove that he was employed by the employer as he has worked for the period of claim. Once this burden is discharged, the burden will shift on the defendant, that is employer, to prove that he has paid the employee for work done, how much he paid the employee for the services. See the case of Ponica Sawmill Nigeria Limited versus Hope. In the case at hand, the employment of the claimant by the defendant as Chief Magistrate Court Grade Level 2 is not in doubt, as the defendant have admitted it in their paragraph 1 of the statement of defense. They have also admitted not paying claimant for the period of claim. The only dispute is on the defendant's assertion to the effect that cancellation of claimant's appointment as per exhibit CW1K means forfeiture of the claimant's earned salaries, as according to the defendant's acceptance of the second appointment by the claimant amount waiver of her entitlement under her previous employment, evidenced by exhibit CW1A and CW1B. The position taken by the defendant regarding the claimant's claim of 27-month salaries suggests that the defendants are oblivious of the fact that the claim of the claimant on payment of arrears of salary and paid salaries was a claim for an entitlement which in law cannot be unilaterally cancelled by the defendant. The claim of arrears of unpaid salaries being an entitlement cannot be affected by any purported cancellation of contract of employment based on which entitlement was earned. The Supreme Court has made it abundantly clear that an employee whose contract has been terminated or dismissed retains the right to claim for his earned entitlement. See the case of Udegbunan versus FCDA, reported in 2003, 10 Nigerian Wikilolo Report, Part 829, page 487. See also Underwater Engineering Company Limited versus Dubifam, 1995, 6 Nigerian Wikilolo Report, Part 400, page 156. See also Kasali versus Olubenga versus Access Bank PLC. In view of the foregoing position of the law, I found that the claimant is entitled to her 27-month salaries arrears and paid salaries arrears for services rendered to the defendant. On the subsequent appointment of the claimant to a lower grade level as per exhibit CW1K and CW1L, the defendants by their pleading allege that the cancellation was done by the governor of Cross River State, and fresh appointment which purportedly cancelled the previous appointment of 2019 was due to review of said defendant and through the second defendant. The executive governor approved it. The question that need to be answered here is, do the defendants in this case and the executive governor of Cross River State have power on their own to review the existing contract of employment without the consent, knowledge, and or agreement of the party whose appointment was reviewed? All the defendants in this case and the executive governor of Cross River State are creation of the Constitution of the Federal Republic of Nigeria 99 as amended. The Constitution of the Federal Republic of Nigeria as amended has assigned duties and functions to each one of them. The third defendant was established as one of the executive bodies as per Section 197C of the Constitution as amended. with powers to appoint and exercise disciplinary control over magistrates in Cross River State. Therefore, the claimant who was appointed by the third defendant is under the control of the third defendant and not of that of the executive governor of Cross River State, who by the clear and unambiguous provision of Section 202 of the Constitution of the Federal Republic of Nigeria as amended is an independent body established under the Constitution and made to be free from interference in carrying out its duties and function as it is required not to take directives or instruction from anybody or person. The provision of Section 202 of the Constitution of the Federal Republic of Nigeria as amended is very clear and unambiguous in that no authority or person is allowed to interfere with the exercise of the power of the third defendant or direct its affairs. The Constitution has established the third defendant and made it to be free from any control or interference in carrying out its constitutional function. Therefore, the purported cancellation of the appointment of the claimant having been made based on interference of the governor of Cross River State cannot stand. The third defendant is in acceding to the request or direction of the executive governor regarding cancellation and reappointment of claimant to a lower grade level acted in abdication of its duties. The Constitution having prohibited such interference, the said cancellation is null and void and of no effect whatsoever as it was done in the contravention of the constitutional provision. It is clear to me from the pleadings and evidence before the court the entire processes of the purported cancellation of claimant's appointment as per Exhibit CWK and CW1L was shrouded in secrecy until when Exhibit CW1K and Exhibit CW1A were issued to the claimant. CW1 under cross-examination has stated that a committee was set up under the chairmanship of the Executive Deputy Governor of Cross River State, and it was the recommendation of the committee that was implemented. This piece of evidence has clearly corroborated the claim that the executive governor of Cross River State interfered in the work and activities of the third defendant, that by the constitutional provision in Section 202 is insulated from such interference. By issuance of Exhibit CW1K and CW1L, the third defendant acted in gross violation of the constitutional provisions that guaranteed its independence and non-interference in its function by anybody or forces. Worthy to note is the fact that defendants have also not given any reason why the appointment has to be cancelled. It is clear to me that purported cancellation as per Exhibit CW1K and CW1A clearly evinces act of misconduct on part of the claimant, and for any action to be taken on misconduct, the claimant deserves to be notified or informed of such acts of misconduct against him, which lead to the cancellation of his appointment. It is not only information, that the claimant must also be tried for misconduct and found guilty before such an action can be taken or meted on her. There is no evidence adduced by the defendants to show that the claimant was ever accused of any misconduct or even tried and found guilty of to warrant cancellation of her appointment. The appointment of the claimant, being one that has support from the Constitution, cannot be pushed away at the whims and caprices of the third party, or even by the third defendant itself. The said appointment cannot be tampered with without following due process. The appointment of the claimant having not been made at the pleasure of the defendant for any action to be taken, it must be sanctioned by law, otherwise it will be in futility. The absence of any reason for cancellation of claimant's appointment goes to support the assumption that the cancellation was not made for any act of misconduct. Rather, it was done in carrying out directives of the executive governor of the state based on recommendation made to him. The new appointment as per Exhibit CW1K and CW1L was also as a result of approval of the executive governor. All this goes to show the executive governor did not allow the third defendant to perform its function free from any interference. The facts of this case clearly shows interposition in a function that is clearly not business of the executive governor of the state. This clearly established executive meddlesomeness in the affairs of the judiciary, which should be defecated and condemned. In the case of Hart versus military governor of Rivers State, the highest court of the land, the Supreme Court, has frowned at such kind of interference by executive in the affairs of the independent bodies, such as third defendant. But viewed it with such frightening stance. The appeals court set aside the order of military governor in Hart versus military governor of Rivers State, even when it was clear that the military governor did not deliberately intrude but was invited into the fray by the public service of Rivers State without any prompting from the governor. It is without any doubt that Section 202 of the 1999 Constitution has granted absolute independence to the third defendant in the matter of employment and discipline of its employees. In this wise, the very proceeding of the third defendant, the Judicial Service Commission regarding the claimant, was jaundiced by the virtue of Kankawam external interference of the executive governor as the third defendant carried out instruction or directives of the executive governor. Therefore, the cancellation is liable to be set aside for perverting the course of justice, being a product of outside interference or dictation. The situation in the instant case is somewhat similar to an essential aspect to that of Nawa versus Attorney General of Cross River State, reported in 2007 LPLR 8294, wherein the governor of Cross River State unilaterally retired the plaintiff's appellant without resort at all to the Cross River State Civil Service Commission. The legal effect of interference of the governor of Cross River State in Nawa's case is the same with the instruction or directives of the governor of Cross River State for cancellation of claimant appointment as per Exhibit CW1K and CW1L. The legal effect is one and the same. In our case, the governor acted directed the issuance of the letter of retirement, and in this one, the governor did it by directing the Judicial Service Commission of Cross River State to cancel third defendant to cancel appointment of the claimant and demote her without commissioning any act of misconduct. The act of cancellation of the claimant appointment and unilaterally appointing her to a lower grade level without any hearing is ultra biased. The powers of the third defendant. What happened is that the executive governor of Cross River State used the third defendant to perpetuate illegality. In Nawa's case, the Court of Appeal set aside the order of the governor and reinstated the plaintiff. In the instant case, since it is order of the executive governor that was carried out in cancelling a appointment of the claimant to a lower grade level, the cancellation and new appointment of the claimant as per Exhibit CW1K and CW1A are vitiated and liable to be set aside, as no valid cancellation or appointment could be sustained. The law is that unilateral termination of contract does not terminate the contract. See Opelo versus NEPA PLC. In the circumstances, I hereby set aside the cancellation of the claimant's appointment and her appointment to a lower grade level as shown by Exhibit CW1K and CW1L. These exhibits having been found to be null and void are hereby set aside. The claimant has also stated that the second contract of employment was executed under duress. In response, the defendant stated that the claimant's acceptance of the new appointment offered to her by the third dependent wherein the earlier appointment of the claimant to Chief Magistrate Grade 2, Grade Level 15 was cancelled, such that the new appointment of Magistrate Grade 2 was not under any coercion, nor was claimant under any compulsion to accept the offer, as she had unfettered option to either accept or reject it. It is also the case of the defendant that the claimant did not only accept the new appointment, but proceeded to collecting salaries and continued to perform her duties under the new contract. It was also stated that the claimant willingly entered into the new contract of employment with such defendant in April 2021. By entering willingly, has waived her right and entitlement under the previous appointment. In his pleading and evidence before the court, the claimant stated that her acceptance was under duress. In proving this allegation of duress, the claimant pleaded particulars of duress in paragraphs 22 and 23 of the statement of fact. From these paragraphs of the statement of fact, it is clear to me that claimant was pressurized to accept the contract of service, which placed her on a lower rank that is not commensurate with her qualification and experience due to the financial constraint. With the non-payment of claimant's 27-month salaries, the claimant was forced to accept whatever offer that comes across her in order to be able to survive. I find that the claimant was coerced into accepting Exhibit CW1K and CW1L. The acceptance was not free from pressure, nor was it voluntary. It was done due to other options as a result of financial pressure. I quite agree with the counsel for the claimant that duress need not to be physical. It may be otherwise or financial, as in this case. See the case of Calabar Central Cooperative Thrift and Credit Society versus ECO. See also FCMB PLC versus Bembok Limited. On laches and acquiescence, these are special defenses that refer to slackness and unreasonable delay or negligence in pursuing a right or claim in way that prejudices the party against whom relief is sought. Acquiescence, like laches, is a person's tacit or passive acceptance or implied consent to act. Being equitable defenses, they must be considered based on particulars of fact of which the case under consideration. However, account is taken of the actions and behavior of the claimant and the defendant, and sometimes the impact on third parties. There are certain factors to be taken into consideration. See Taiwo versus Taiwo, see Kayode versus Odutola, see Odutola versus Ibadan City Council, where Pataye Williams JSC as he then was stated that a plaintiff faced with the defense of laches and acquiescence may succeed in his claim if he can make a reasonable explanation for the cause of delay to assert his right. Such explanation may be that he was all the while ignorant of the right, or that he lacked full knowledge of the existence of such right, or that he was all the while under legal disability or incapacity, or three, that he was under undue influence, or that he lacked free will. The claimant has, in response to the equitable defenses of laches and acquiescence put up by the defendant, argued that the claimant was not indolent and never rested in her pursuit of her rights. As she had protested. See Exhibit CW1H. It was also argued by the counsel on behalf of the claimant that there is necessity for the defendant to plead the equitable defenses. I quite agree with counsel for the claimant that final written address is not the appropriate forum for putting up defense of laches and acquiescence. These are special defenses that the law requires the defendants to specifically plead them in their statement of defense. Having not done so, they must fail as they were not appropriately raised before the court. See the case of Adeniran versus Alao. See also Anyaro versus Anyaro, and that of Alabi versus Dohati. One other vital issue to be considered is party raising the equitable defense must have clean hands. This is one of the cherished maxim of equity, that he that comes to equity must come with clean hand. See DPCC Limited versus PC Limited. See also Elau Bache versus Phillips. See Apolabi versus Mudan Shiru. See Anima Shaun versus Bakare. The question to ask here is, can the defendants in this case be said to have come to equity with clean hands in raising the equitable defenses, having regard to the facts as disclosed by the pleadings and evidence before the court? There is no doubt the defendants, having denied the claimant 27 months salary after having worked and earned same, cannot be said to have clean hands. They are guilty of wrongdoing, i.e. denial of claimants have salary for 27 months. Therefore, it will be unconscionable to allow the defendant to raise equitable defenses of laches and acquiescence which they are attempting to raise here. The law will not allow them to benefit from their own wrongdoing. See Umaru versus Farm. From all I have been saying above, the claimant has been able to establish his case by preponderance of evidence, to prove her case by preponderance of evidence as required by law. Therefore, she is entitled to her claim. In view of the above finding, I hereby order as follows. 1. A declaration is hereby granted that the employment of the claimant as Chief Magistrate Court to salary grade level 15 in Cross River State Judiciary with effect from 3rd of February 2019 is still valid and subsisting. B. A declaration is hereby granted that the third defendant purported cancellation of the claimant's appointment of 3rd day of February 29, 19 as Chief Magistrate 2 grade level 15 in Cross River State Judiciary, and purported appointment of the claimant by the third defendant as Magistrate Court grade level 2 of Cross River in the Cross River State Judiciary with effect from 17th May 2021 is illegal, unlawful, null and void, and of no effect whatsoever, as the said action have no support in law and equity. C. A declaration is hereby granted the claimant is entitled to salaries and emolument due to other magistrates in the Cross River State Judiciary on the same rank and salary grade level, which the claimant was appointed with effect from 3rd of February 2019. D. The defendants are hereby ordered to pay the claimant the sum of 12,207,530 naira 26 kobo, being unpaid arrears of claimant salaries from the month of February 2019 to April 2021, and shortfall in the salary paid every month to the claimant from May 2021 to March 2022. The defendants are hereby ordered henceforth to pay claimants her salaries as Chief Magistrate Court Grade Level 15. The defendants are hereby ordered to reinstate the claimants back to her rank and position of Chief Magistrate Court Grade Level 15, the position which she was appointed as by Exhibit CW1A. The defendants are hereby ordered to pay claimant the sum of 300,000 naira cost, 300,000 naira as cost. This judgment is with immediate effect. Judgment is hereby entered accordingly.
As the court pleases. My Lord, we are much obliged. We wish my Lord good health and long life so that my Lord can continue to dispense justice to the public. Thank you, my Lord. Thank you, my Lord. I'm grateful, sir.
My Lord, we are.
Thank you, Doctor.
We are grateful for the.
It's all right. Registrar, call the next case.
Yes, my Lord. This number NICN CA 61 2022 between Elizabeth Umo.
Yes.
Present.
Yes, Registrar.
My Lord, the parties are absent.
No, the claimant is
online now. Present.
Claimant is online. Yes, appearance.
With great respect, my Lord. My Lord, I'm P.O. Aripo. My Lord,
Yes.
humbly for the claimant, sir.
It's all right. Yes, Doctor.
With profound respect, my Lord.
Yes, yes.
Doctor, I of my Lord, I appear for the defendant.
This matter is for judgment. The judgment is ready. The judgment of the court goes like this. The judgment in this suit was slated to be delivered on 9th of April 2024. However, due to the likelihood of 9th of April falling on public holidays, this judgment was brought forward today, 5th of April 2024. The claimant in this case, by the general form of complaint, approached this court dated 4th of approached this court claiming against the defendants as follows. I think that I should skip reading the reliefs. I will keep reading all the preliminaries. I think I will just go to the decision of the court. I have the body of the judgment captured the case of the claimant, that of the defendant, the submissions of the defendants, the submission of the claimants, and for the court decision, I have considered the pleading evidence led by the parties as well as written and oral submissions of counsel for the parties regarding the case put forward by the claimant before the court. Looking at the facts and circumstances of this case, the issues that need to be resolved is whether evidence adduced before the court, with the evidence adduced before the court, the claimant has proved entitlement to any of the relief sought. The claimant in her reliefs 1 to 4 is seeking for declaration, while the remaining 5 reliefs are for order of payment of arrears of salary shortfall and payment until judgment is delivered. The designation of status of claimant to a rightful status as senior magistrate grade level 2, grade level 13, general damages in the sum of 10 million for judgment interest of 10%. I commence with the issue raised of statutory labor by the counsel for the claimant. So I dealt with it like in the other sister case. So I will also skip reading the conclusion there is that the claimant cannot be said to be, the appointment of claimant cannot be said to be that of civil service. And on the main issue for determination of the substantive issue, the argument in this case and that of the preceding case just delivered were all the same. The pleadings, the submissions, and everything is the same except the name of the claimant. It is only the name of the claimant that differs, and also the numbering of the exhibits differs. So the numbering, the exhibits are different, but I also relied on section 197 and 202 of the Constitution in determining whether the employment of the claimant still subsists and whether the cancellation of the appointment of the claimant was proper, and I came to the conclusion that the appointment of the claimant, that of 3rd of February 2019, subsists. It is still valid, and that of 27th of May 2021 is null and void and of no effect because it was not as a result of independence consideration of the third defendant, it was as a result of interference by the executive governor of Cross River State. I also relied on the cases of Nawa versus Attorney General of Cross River State and that of Hart versus military governor in nullifying the decision of the third defendant to reappoint the claimant and cancel the already existing contract between them. On the issue of payment of salaries, it is my finding that the claimant is entitled to earn salaries for 27 months, as the Supreme Court has settled that once a claimant is dismissed or terminated, he still retains the right to claim his earned entitlement, either salary or allowances or leave grant or whatever. He's entitled to recover all the earned entitlement. I have also of the view that the issue of laches and acquiescence raised by the defendants has no place in this case, having not been pleaded in their statement of defense. They cannot raise it in the final address. At the end of the day, I came to the conclusion that the claimant has established her case and she is entitled to her reliefs. I granted the declaration that the employment of the claimant as senior magistrate grade 2, grade level 13, as shown by Exhibit B in Cross River State Judiciary is still valid and subsisting. I also granted a declaration that the purported cancellation of the claimant's appointment of 3rd of February 2019 is null and void and of no effect whatsoever. The said cancellation is set aside. I also granted a declaration that the claimant is entitled to earn her salaries and emolument due to magistrate of same rank in the Cross River State Judiciary with her. The defendants also are hereby ordered to pay the claimant the sum of 8,914,244 naira 22 kobo as being unpaid arrears of claimant salaries from the months of February 2019 to April 2021 and the shortfall for payment made to her from May 2021 to March 2022. The defendants are also ordered henceforth to pay the salaries of the claimant based on her appropriate grade level of senior magistrate court 2 grade level 13. The defendants are also ordered to reinstate the claimant back to her position as senior magistrate court in the service of the third defendant. The defendants also are ordered to pay 300,000 naira as cost to the claimant. The judgment is to take immediate effect and it is accordingly entered. Today, the 5th of April 2024.
The court pleases. My Lord, again, we are most grateful to the court. My Lord, we can only pray for wisdom, good health for my Lord to continue to dispense justice to the public. My Lord, we are grateful. Thank you, my Lord.
Okay.
Thank you, sir.
Yes, Registrar, call the next
We
guest.
appreciate my Lord.
Okay, thank you, Doctor.
Suit number NICN CA 01-2023 between Maureen Nkoyo Esquire and one, the government of Cross River State through the Attorney General and Commissioner for Justice, Cross River State. 3, Cross River State Judicial Service Commission. My Lord, the parties are absent.
Yes, appearance.
With great respect, my Lord. My Lord, I am P.O. Arepo. My Lord,
Yes.
humbly for the claimant.
Okay. Yes, Doctor.
With profound respect to my noble Lord,
Yes.
Dr. N.I. of the Lord, I appear for the defendant.
Yes, this matter is for judgment. The judgment of the court is ready. And it goes like this. On 11th of January 2024, the counsel for the parties in this case adopted their final written addresses and the case was adjourned to 9th of April 2024 for judgment. However, considering the fact that the 9th of April 2024 may likely fall within the public holidays, this matter was brought forward to today, 5th of February, for judgment. By the general form of complaint dated 22nd day of July 2022 and filed on the same date, the claimant instituted this suit against the defendant, praying for the reliefs the claimant is claimed have been reproduced in the body of the judgment. I have also reproduced the case put forward by the claimant as per her pleadings and evidence. I have done the same thing for the defendants. I have also captured the submissions of defendants, the submission of the 3 issues formulated by the defendants. I have also captured the submissions of counsel for the claimant on the 3 issues formulated for determination by the court. I shall straight away go to the decision of the court. I have considered the pleadings, evidence laid by the parties, as well as written and oral submissions of counsel for the parties regarding the case put forward by the parties. Looking at the facts, the issue and circumstances of this case, the issues that need to be resolved is whether by the evidence adduced before the court, the claimant has proved her case to be entitled to any of the relief sought. I also started with the issue of statutory labor as in the previous two cases, so I shall also skip that. On the substantive case, on the claim of the claimant, I also, like in the previous cases, relied on section 197 and 202 of the Constitution to come to the conclusion that as well as the cases of Hart versus military governor of Rivers State and that of Nawa versus Attorney General of Cross River State, to come to the conclusion that the employment of the claimants by the defendant as at 3rd of February 2019 still subsists. It is still valid and subsisting. I also nullify the second appointment of the claimant to a lower grade level because it was not properly done. It was as a result of interference by a third party and also an indication of abdication of function by the third defendant. At the end, I came to the conclusion that the claimant has proved her case and entitled to the relief sought. From all I have been saying above, the claimant has succeeded in proving her case on balance of probability, i.e. on preponderance of evidence, as evidence adduced by the parties when put on the scale of justice. The evidence adduced by the claimant tilts the scale in favor of the claimant. In these circumstances, it is hereby ordered as follows. A declaration is hereby granted that the employment of the claimant as senior magistrate grade 2 level 13 as shown by Exhibit B in the Cross River State Judiciary as at 3rd of February 2019 is valid and subsisting. B, a declaration is hereby granted that the third defendant purported cancellation of claimant's appointment of 3rd February as senior magistrate court is null and void and of no effect whatsoever. I have also nullified the appointment of 17th of May 2021. A declaration is also granted to the claimant that the claimant is entitled to her salaries and emoluments due to other magistrates in Cross River State on the same rank and same grade level with her on her appointment on 3rd of February 2019. The defendants are also ordered to pay the claimant the sum of 8,914,244 naira 22 kobo, being unpaid arrears of claimant salaries from months of February 2019 to April 2021, and shortfall in the salary paid every month to the claimant. The defendant are hereby ordered henceforth to pay claimant salaries as senior magistrate grade level 2, senior magistrate 2, grade level 13. The defendants are also ordered to reinstate the claimant back to her position as senior magistrate court. The defendants are also ordered to pay the claimant 300,000 naira cost The judgment of this court is to take immediate effect. That is with effect from today, 5th of April 2024. Judgment is entered accordingly. Yes.
My Lord,
Judgment is entered.
my Lord, again, we can't thank my Lord more. My Lord, this is a wonderful start package for us. My Lord, we are grateful, sir. My Lord, thank you for holding the law and being there for the oppressed and the poor, sir. Thank you, my Lord. We are grateful, sir. We are grateful, sir. Thank you, my Lord.
Yes, I think we have a new system now. You can even, if you want to obtain CTC of the judgment, you can obtain it online. You don't need to reapply to the registrar, this and that. We have provision now. You can apply online to get your CTC. You can visit our website. When you visit our website, you will see the instruction there. How you can obtain.
But my Lord, we need to pay for certification. That's why we
yes, you need to pay. You need to pay.
Then we like applying and coming fiscally.
It's all right.
Yes, my Lord. It's okay, my Lord.
Whatever method you choose is just to make the alternative. That's why the online certification was introduced.
It's okay, my Lord. My Lord, we are grateful, sir. I'm highly grateful, sir. Thank you, my Lord.
You're welcome.
My Lord, wish you happy and good health.
Thank you very much. Registrar, any other business? It appears the registrar has disappeared.
Maybe it is offline, sir.
Yes. Thank you, Council. We have come to the end of today's proceedings. The administrator, you can end the sitting. Thank you, Council, for being.
My Lord, have a nice day and good health, sir. Happy Easter.
Thank you. Same to you. Bye.